On behalf of Jeff and I, as the organizers, thank all of you for coming to these two conferences to study prejudice and stigma. I think in the division of labor, I'll do a brief introduction for the theory side, and Jeff will for the empiric side. Of course, with the observation that that's not a very natural division. The questions that are being asked don't dichotomize, but it's hopefully through interactions with in a complementarity sense that this division will be useful. I think by way of background, all I would say is that, obviously the last year has caused an enormous amount of soul searching, not in just the country, but in academia, to think about issues of racial justice and racial inequality. And what this particular pair of workshops is trying to do is to facilitate communication between different areas of social science to improve the quality of research. And I think in stepping back, as to where things are, I would speak as an economist to say that there's obviously deep issues of prejudice, of systemic discrimination, of racism that are not natural kinds in the formal models that economists develop, or in many of the econometric exercises that are foundational to evaluating racial disparities. And so, speaking for myself, that's what I want to benefit from. In other words, I want to know if sociologists, psychologists, legal scholars, and think about these questions in ways that can enrich the particular formalisms that it lists that I would focus on. I could obviously give analogous discussions for each of the disciplines that's represented here, and I skipped political science. I saw Anthony gave me a dubious look, and so the point is all of them, I think, interact. In terms of the organization of the presentations, we've asked each of the speakers to give a 20-minute or so talk. We're going to ask the questions be held until the end. If there's an absolutely essential clarifying question, then it's okay to ask in real time, but we thought that organizationally it was most sensible to give people an opportunity to communicate. So let me finally say that this is a joint activity between the Committee on Social, Behavioral, and Health Sciences and the Human Capital and Economic Opportunity Global Working Group. The committee is one of the University of Chicago committees, which in a good faith sense is interdisciplinary and brings together both statisticians, natural scientists, and social scientists to discuss its eponymous, the issue of quantitative methods. The Human Capital and Economic Opportunity Group is an international network of scholars, which is co-directed by Jim Heckman, Robert Duggar, and myself, and has focused on specific, a broad range of inequality issues. And so it was an actual partnership for these types of activities. And so, I want to, Jeff and I, thank both the institutions, both the organizations for the sponsoring. So I think without further ado, it's best to hear what people have to say. Loury Blume from Cornell will be the first speaker. So Larry has done foundational work in a broad range of areas in economic theory. Much of the work have to do with dynamical environments, understanding the evolution of characteristics of populations. And he has done foundational work on the understanding phenomena ranging from stigma to social interactions. And so without further ado, Larry, the floor is yours.
So my interest here is not in the substantive issues around prejudice and stigma at this moment, at least for this talk. But I want to talk about methodology, about modeling strategies for addressing these kinds of phenomena, and I want to make a plea that we start looking at a slightly different kind of model than has been popular before. So let me move. How can I advance my slides there? Okay, so I want to begin by, so I'm going to talk actually almost entirely about methods and theoretical models and style of theoretical modeling. I'm going to talk about the reduction of social behaviors to rational choice. I'm going to talk about what I think has been missing, at least in a lot of economic analyses, which has to do with the social construction of preferences. And then finally, I'm going to talk about a modern view of evolutionary game theory, not the old biological models, but what people are really doing today, and try and present that as a useful modeling strategy for the macro dynamics of social systems. Now, I think the phenomena that I'm most interested in is that which Gunnar Myrdal described in his book An American Dilemma as vicious circles. So, in this book, he deploys an idea which he calls the principle of cumulative causation to talk about the co-determination, the co-evolution of beliefs and actions. And I think that this principle is a remarkable intellectual achievement. Stephen, you will appreciate the fact, I think, that he published this idea first not in an American Dilemma, but in a book on monetary equilibrium, which he published in Swedish in 1931. And to me, it's a remarkable achievement because it's a dynamical analysis of the co-determination of actions and beliefs. And so this predates by some 20 years the kind of static analysis that Nash gave us in the 1950s. And today, that kind of dynamical analysis, I think, is best expressed with some of the ideas of evolutionary game theory. My original thought had been to talk about one or two of my own papers as a way of illustrating what I think of as the power of this kind of dynamical approach. But I found that I couldn't reduce anything down to 15 minutes and make it be coherent. So I kind of gave up on that, and I'm going to be a little bit more general, I guess. Let's see. So let me talk first about the what I think of as the reduction of behavior to rational choice. To rational choice models. So on the left are words that are associated with various models of stigma that are found in on the literature, the social science literature, in particular the social psychology and sociology literature on stigmatization. So in the center is a brief but coherent description of the rational choice model for choice in environments with uncertainty, at least as most rational choice social scientists understand it. So in the rational choice model, there are four components. Objects of choice assign outcomes to descriptions of the world, states of the world. There's a set of feasible choices, which is constrained in some way. And this is important because when we think about policy analysis, for instance, we're thinking about perturbing that feasible. One way of doing this is to think about perturbing the feasible set in some way. Tastes are represented by a value function, which assigns values to the outcomes of actions that people choose, beliefs are represented by some way of averaging over sets of states so that we can reasonably talk about the expectation of values, of the values of the outcomes of choice. And I want to make it clear that that last sentence was really a little bit vague because my interpretation of this includes things like loss aversion, like cumulative prospect theory, Choquet expected utility, which involve which go far beyond expected utility in their expressiveness, but still basically have this kind of same idea. A key idea in all of these things is that tastes and what people like and beliefs, what they think about the world, are in some way separable. Now, all the richness of the descriptors on the left get compressed into the center model. And there are three things to note about that. So the first thing is that the center model, the rational choice model, the subject of it is intentionality. And therefore, it's very useful for talking about things like wage disparities in labor markets. But I think it's equally useless for talking about non-intentional behaviors, such as many of the behaviors that today are called microaggressions, and yet which I think are important for our understanding of stigma, prejudice, and the way that that affects individual intentional individual behaviors of the aggressees, so to speak. The second thing is that it's nearly a hermetic model, that individuals are regarded as atoms, and there's only a small port through which the world can enter and affect the atom, and that is the only path from the world into the choice process is through beliefs. So all social cognition is mediated through beliefs. Tastes are isolated from the social interaction. The third thing about this model is that it's extremely parsimonious. And I think that this of course is actually its virtue, because we're not interested, I think, and there are economists who will disagree with me on this. I'm not particularly interested in individual behavior. I'm interested in the behavior of systems of people, societies, populations. And if, for example, I had to run a model of the brain for every single individual in a large population, you would never get that off the ground. So I think that if you're interested in what you might think of as general equilibrium modeling or population modeling or something like this, you need to have a model which on the one hand is as expressive as possible, so that it can capture lots of behaviors, but on the other hand is really easy to manipulate. And maybe the single virtue of the rational choice models, we understand it, is that it kind of threads that needle. So in any event, all these rich ideas of stigmatic process have to pack into these three components. The last thing I want to point out about this model is that although most users of the model think of tastes and beliefs as being distinct, and beliefs as having a somewhat different ontological status than does tastes or do tastes. But Jimmy Savage taught us back in the 1950s that tastes and beliefs are just one way that one can sometimes describe a more fundamental notion of preferences. So as you know, he starts with Savage starts with preference orders and derives out of that. He says if preferences look a certain way, have certain properties, then we can represent them as having tastes and beliefs represented in the usual expected utility way. But that doesn't mean that these things necessarily have that are not necessarily things in themselves. They're really just a way that we can express preferences so as to manipulate them in our models. And in Savage's framework, I suppose a Bayesian updating of beliefs is just a very particular kind of preference revision. And even there, with thinking about it, its domain is very limited. Number one, it only has to do with updating beliefs, not updating tastes. Second, of course, it can't update on impossible events. And third, Bayesian updating really can't deal with non-partitional information. And if you have questions about what that might mean, we can talk about that later. So let me move on quickly, because I'm not being careful about monitoring my time. There are, in fact, two varieties of game theory that are out there. Epistemic game theory is what we usually study in the classroom, what is taught in any class on non-cooperative game theory. It's called epistemic because, and I think that the term is due to Ken Binmore, because it has to do with how people represent the world. And as Tom Schelling put it, looking into the mind of my opponent, I see him looking out back at me. And it's this kind of infinite regress of looking at the other, trying to think about what the other thinks about what you think, which of course is what you think about the other, and going back and forth. This is the idea that Nash equilibrium, as we usually understand it, expresses. Nonetheless, game theory is one way of opening up this hermetic environment of the rational actor choice model, because in the classroom version of game theory, in the epistemic version of game theory, tastes are given, but beliefs are not given. Beliefs emerge endogenously as equilibria of the model. beliefs are not given, but given the exogenous tastes of all the individuals playing a game, and the restriction to rational action, the beliefs that we call equilibria are those that are not contradicted by the choice data that we see. Nash equilibrium, as I understand it, is really an equilibrium of beliefs. It's not really a theory of action per se. Now, the object so evolutionary game theory is not much taught these days. It replaces rational action with quasi-rational dynamics about the adjustment of play, learning how to play the game, trying out different kinds of things, experimentation. More sophisticated models, develop learning behaviors that are themselves plausible, but are not necessarily linked to the probabilistic updating that Bayesian dynamics forces on us. And the object of study in evolutionary game theory is not what individuals believe or what individuals do, but it's the distribution of choice in a large population of players. So the toy model is of game theory is well, actually, let me go backwards and say that the toy model of evolutionary game theory is a population of individuals who pair off in some kind of pairwise interaction, for example, to play chess. But it also turns out to be useful for describing much richer kinds of strategic interactions, such as Beijing traffic jams of the kind that you can see on the right. There's a further class of models, and this is really what interests me the most, so-called indirect evolutionary models, which describe the evolution of preferences rather than that of play, so that they really are about the social determination or the social construction of preferences, which is what I think we really need to get at to, as I've said before, to talk about stigma and prejudice. So as I said, I had originally wanted to talk about a somewhat rich model of stigma, but there isn't really time to do that. So I thought that instead of that, I would choose another toy model, something that I've used in the classroom, just to illustrate how evolutionary thinking looks very different from traditional game theory. Here is a very simple game that's actually modeled, built off of the ultimatum game. So here's the story behind the game. We have two units of resources that players 1 and 2 must somehow share. And players 1 and 2 at the outset choose simultaneously whether to try and exploit the other person or to act in a fair way. And so these strategies, the little circles indicate when someone gets to choose. The dots connecting player 2's first two choices indicate that player 2 doesn't know what player 1 has chosen when it's his turn to choose. That is, he doesn't know whether player 1 chose X or F. So this is a way of modeling a simultaneous choice of the two players. Players 1 and 2 each choose whether to act exploitatively or fairly. And if they both, and as I said, there are two units of a material resource which needs to be distributed. If they both act in a fair manner, they end up splitting the pot. And you can see that on the far right. If one exploits and the other is fair, acts fairly, then the fair chooser now has, and this is a deviation from the ultimatum game. Well, actually, it's really not. The fair chooser has the choice to either yield and accept the outcome or to retaliate in some way. Okay. And if she yields, she gets nothing, and the exploiter gets everything. And on the other hand, if she retaliates, then the exploiter gets nothing, And she gets some utility, which is not a material utility, it's a psychic utility, which might be either positive or negative, depending upon whether she is an aggressive individual or a reluctant individual. And so we're going to imagine a population of people. I guess the way that we really think about this is that there's a whole large population of people, and people are randomly assigned to be paired up to play this game. And some of these people there's a distribution in the population. Some are retaliators. Some are reluctant individuals. I don't know a good word for that off the top of my head at the moment. And they're matched to play this game. And what evolutionary game theory is about is at the end of the day, now your utility here, the C plus or C minus is not an object of choice. So C plus is positive number, and that indicates that you like to retaliate when someone has tried to screw you, so to speak. And C minus is negative, meaning that you are reluctant, that you just let it go, okay? And as I said, you can be either one or the other. Now, what evolutionary game theory does is envision some kind of dynamic where people leave the population, join the population, maybe reproduce, or they learn by looking at the experience of others. All these lead to different kind of dynamic models that are going to give us the same outcome here. And those outcomes are going to depend upon the material outcomes of playing the game. And I should say, by the way, that in the event that an exploiter tries to exploit someone who has chosen to act fairly, and then that fair person, that fair chooser resists, the material outcomes to both players are zero. So it's the same thing as if it's the same material outcome as if they had both decided to exploit. But nonetheless, but at least for the person who chose to act fairly, at least there's some, additional psychic benefit. And the key idea here is that social and private needs may diverge. So private intentions as captured by individuals' utility functions might be distinct from what, in this context, a biologist would call fitness. Stephen, I'm just about done because I must be almost out of time. When we match people up to play this game, they know themselves whether they are a plus or a minus, and they know whether their opponent is a plus or a minus. And in each one of these four versions of, well, there's actually 4 versions of the game, and there's a little typo. No, that's right. Okay. There are 4 versions, 3 versions of the game. 2 pluses could meet, 2 minuses could meet, or a plus or a minus could meet. And these outcomes are detailed. These are the material outcomes that you see in the little box on the right of the slide. Now, what evolution does, as I said, is it works on the material payoffs. One can study any one of a variety of dynamics that talk about how the population is going to adjust to the play of the game, to the flow of material goods, material payoffs that come out of the play of the game. And for any notion of evolutionary equilibrium, or such as evolutionary stable strategies, or any dynamic process such as a replicator dynamic or imitation dynamics, or some kind of different kinds of learning dynamics. All of the outcomes lead to the population evolving to one in which being aggressive in response to exploitative play dominates the population. And this is not a story of a Bayesian adaptation. This is really a model of a part of the utility function changing in response to the flow of goods or the flow of material resources that goes in the population. So this is a very different point of view than what traditional game theory does. Finally, let me conclude by saying, well, what can we learn from such things? if we look at laboratory studies or field experiments about stigma or prejudice, I think these are incredibly valuable, and they look in a detailed way at the mechanisms and outcomes of stigma, and prejudicial behavior. So they answer questions that I think of as micro questions. So, for example, Betsy Pollack, you're here, right? I can't see you because I can't, if I'm sharing my screen, I can't see who's here. But Betsy and co-authors have a nice annual review survey on experiments having to do with prejudice. And I have to say, it was really depressing to read, because it seems that we know so little, and that the things that we hope might work out really don't work out so well. So one thing that for example that I learned from this review is that people talk about what are called light touch interventions to change prejudicial thoughts and actions of other individuals, and these are the kind of the psychic equivalent of nudges, small little interventions that the hope is, I think, to make people stop and think. We can really learn a lot from experiments about micro level processes, the microdynamics of how people respond at an individual level to various kinds of interventions that we might make. But what we miss, I think, what at least I can't imagine how experiments could do this, at least with the technologies that we now have, is to address macro questions about what happens when we scale things up at a population to a population level. So, for example, does the effectiveness of light touches wear off if it is continuously deployed over a period of months or years in a large population? What are the consequences of a core population that are immune to interventions, but who can continually reinfect the population with, so to speak, which to kind of re-incentivize prejudicial behavior? What would an equilibrium look like in such a population? So this is the kind of thing that the population game theory or evolutionary game theory is designed to address, these macro questions. And there's a number of things that such models have taught us over the years. So, for example, in games where the dynamics are about actions rather than preferences, Nash equilibrium still turns out to be a focal concept, but some equilibria are more focal than others. One thing we've learned is that changes in model behaviors can shift focality without actually shifting the equilibrium themselves. So what I mean by focality is that if we actually look at some of these dynamic adjustment processes, we might have a game which have multiple equilibria, and some of the but these adjustment processes will tend to take us to one equilibrium, and we'll spend much more time in the neighborhood of one equilibrium than we will in another. So I wrote a paper some years ago about statistical discrimination, wherein I discovered that some seemingly innocuous or seemingly good sounded policies, in fact, could shift the focal equilibrium from being the good equilibrium to the bad equilibrium. And I won't go into any more detail than that. Another thing that we learn is that adjustments dynamics are very nonlinear. There are cascades, and cascades are really driven by and what I mean by a cascade is that the population will look one way for a long time, and then very quickly it will shift to a different mode of behavior. Where does these kinds of cascades come from? These cascades come from threshold and individual behaviors. They also come from what game theorists call strategic complementarities, by which I mean that imagine that there are some actions that I could choose from, and to the extent that or that any individual could choose from, and to the extent that, for example, more individuals choose action A, this makes action A more valuable relative to other choices for those who haven't yet chosen it. And so coordination becomes self-reinforcing. So one example would be that to the extent that that a community stigmatizes certain types of individuals or behavior, participation in that stigmatization activity validates community membership. And so the incentives for participation actually increase the more that people do this. This has implications for empirics, which I hope someone else will talk about. Because this creates a lot of estimation problems for trying to measure macro effects. A third implication or third thing we learned is that heterogeneity drives dynamics. Stephen, am I out of time yet?
Yes.
Okay. All right, good. Then I won't say anything more about that. The other thing I will say about this, which I guess I find a little bit discouraging, is that very, very small details of process matter. And so consequently, small changes in some aspects of a model can, models are not very robust. I guess sometimes they're not very robust, and this is an understudied area. And this is something I think that we all need to think about. I'll just conclude by saying that the promise of such models is that we have this very rich social psychological literature from social psychology that talks about how stigmatization works, how prejudice can work, but we don't have any way yet of integrating that with looking at the macro effects in populations. So I want to suggest the modeling strategies that I've touched on here as a way of approaching that. And I haven't posted any papers yet, to share, but perhaps I could put up a little bibliography that might point to some papers that I think are key in this literature, which show how these tools could be used to bridge this gap.
So our next speaker is Sonja Starr, who is the John Krieger Professor of Law and Criminology at the University of Chicago. And this is a good example where I've been reading somebody's papers for years, so it's very nice to have a face associated with a research program. Professor Starr has done foundational work on the interactions of the aspects of the criminal justice, the legal system more generally with inequality, and particularly racial inequality. And I would personally highlight both her work on algorithmic fairness with respect to criminal decisions, as well as her work with Amanda Agan, who I think is listening in on the effects of ban the box policies. So it is wonderful to have you. Thank you.
Thanks so much. I'm going to talk without slides. So I'll say, I'm a law professor who studies disparities and discrimination in criminal justice and secondarily in employment. And I mostly do it from an empirical perspective. My work is mostly in the field of empirical law and economics. I publish in law journals and econ journals. I also engage a lot with criminologists. So my perspective is shaped by exposure to multiple disciplines, and I'm going to comment today on some differences that I have noticed. But also, although I have been asked to be on the theory panel, because I'm mainly an empiricist, I'm substantially going to focus on the way that theory connects to empirics, the way that our measurement of discrimination and disparity is bound up with normative questions about what we value, and the problem with the way that empiricists tend to downplay those questions rather than foregrounding them and interrogating them. And as examples, I'm going to explore a few topics that are connected to my own areas of research. So first big illustrative topic, risk assessment. So one hot topic in criminal justice is the use of actuarial or algorithmic prediction methods to predict future criminal offending. So these tools are, algorithmic sounds fancy, but they're mostly not very technically sophisticated. A lot of computer scientists are hard at work on machine learning approaches, but what are actually in use are mostly much simpler checklists that produce a risk score. And the risk factors include criminal history variables, age, often many variables that are much more controversial, such as socioeconomic characteristics like employment status, history of employment instability, housing instability, et cetera, zip code, which is highly racially correlated, family characteristics, like whether the defendant's parents have been incarcerated. Those things are all statistically correlated with recidivism or crime risk. The resulting risk scores are being given to decision makers at many criminal justice stages in many jurisdictions, like bail magistrates, sentencing judges, and parole boards. And the arguments that advocates of these risk assessments give have real appeal. They say, why don't we use scientific insights to make sure that we're incarcerating those that we need to and not those that we don't? So advocates generally describe these predictive tools with positive terms like evidence-based, scientific, smart on crime. And that language makes them hard to oppose. Who's against science or evidence or being smart? There's a counter argument though, which is that all of these are just euphemisms for a more descriptive term, namely profiling. Risk assessment instruments ensure that our justice system will treat people differently, not because they individually have done anything to deserve it, but because of who they are, how much money they have, and what people who share those characteristics have done in the past. And to the extent that these instruments do rely on the individual's past criminal conduct, they use measures of that conduct like arrest history and conviction history that could easily be tainted by past biases in law enforcement and courts. So I've been on the critical side of this debate myself, but I'm not going to dig into the whole argument here. I want to focus here on more of a meta question and a prior question, which is that before we can assess whether criminal justice algorithms are fair or whether they promote inequality or disparity, we need to ask, what do those concepts mean? So consider, for example, 3 very common ways that we could think about what inequality means in the context of prediction. So the first approach is what lawyers would call the disparate treatment approach. Are decisions being made for the right reasons or permissible reasons? Under this approach, which dominates US constitutional law, fairness and equality depend on how decisions are made and not on their consequences. The key requirement is that we not treat people differently for the wrong reasons, such as their race. So an algorithm's fairness would be judged based on whether the risk factors that go into it are acceptable reasons for the criminal justice system to treat people differently. It's an input-based approach, not output-based. This is the way that US courts think about unconstitutional discrimination. They do not focus on effects, they don't focus on accuracy, they just focus on whether impermissible factors are being taken into account. Second approach, disparate impact. Do some groups face disproportionate negative effects of the adoption of something like risk assessment? Under this view, what really matters is outcomes, not decision-making criteria. For example, we might consider an algorithm racially biased, even if it does not explicitly consider race itself, if there were big racial differences in risk scores. This is also a common way for lawyers and courts to think about racial discrimination, although generally only in the context of statutory law, like employment discrimination law, not in constitutional claims where they're input focused. Third, actuarial fairness. Are the predictions equally accurate for different groups? Under this approach, if the algorithm makes similarly accurate predictions for 2 groups, then it's treating them equally. And this concept is popular among many designers and advocates of criminal justice risk algorithms, perhaps because it makes achieving equality seem like a technical problem. It's my view that crime prediction algorithms raise, or at least frequently raise, serious equality concerns from all 3 of these perspectives. But the point I want to highlight now is just this. These are really different ways of thinking about equality. In most circumstances, they can't all be simultaneously satisfied. Researchers in computer science and other fields are working on ways to address fairness concerns, but often they don't really interrogate which is the best way to think about equality. They pick one, often the one that best suits their data and the methodological tools available to them, and present their analyses as technical or empirical, but the framing of the question is inevitably a normative choice. And I think there's a serious need for dialogue across disciplines about these choices. So I've been in many conversations with computer science colleagues working on this stuff, and again I hear versions of, okay, so why don't we just reverse engineer the algorithm to cancel out racial disparities, either in predictive accuracy or just in the risk scores themselves, i.e. make the algorithms race conscious in a way that help them to become more equitable. And these well-meaning folks have often been surprised when I've said that if you tried to actually use such an algorithm for government decision-making, US courts would surely immediately strike them down. They would not permit racial classifications to be used as inputs into the risk assessment decision, even if the the purpose of doing so were ultimately to reduce unwanted disparities in outcomes or in accuracy. Now, that doctrinal approach may be wrong. Many law professors, including me, think it's wrong to some degree. But to say the least, the Supreme Court is not moving in our direction, and people working on the technical side of these problems need to understand that there are legal constraints on solutions. And meanwhile, people on the legal side, including the judges that apply risk assessment instruments, often don't really understand them at all. They do not understand that they're often baking in discrimination on the basis of factors that judges would never accept if it were not buried inside a risk score with the sanitizing veneer of science. Okay, second big topic is statistical discrimination. So as a law professor who has basically infiltrated the field of economics, this is the topic that has most often given me a sense that I have landed in a completely alien culture. I am talking about the way that economists have focused for decades on the distinction between statistical discrimination and taste-based discrimination, and more recently on the distinction between statistical discrimination and stereotyping. So for other non-economists, here's a capsule summary of what these concepts mean. So taste-based discrimination is often characterized as mere prejudice or animus. For example, an employer hires white people over equally qualified Black people simply because the employer prefers to be around white people. Statistical discrimination is when a decision maker, say an employer, relies on race to make decisions, but not for its own sake, but because it's a proxy for some other interest that the employer has, some legitimate hiring interest. For example, the employer might believe that Black workers are less likely to be productive, more likely to commit crimes on the job. And the idea is that when employers lack sufficient individualized information about applicants, statistical discrimination is often rational from the employer's perspective, so long as there's enough empirical accuracy to the generalization. And moreover, some economic literature has, certainly not all, has gone farther and argued that statistical discrimination can be efficient from a social perspective as well. Stereotyping is a concept that's sometimes treated as interchangeable with inaccurate statistical discrimination, which everyone agrees is irrational and inefficient. So think of the employer relying on racial generalizations that have little to no basis in reality. So I want to make clear first that my objection isn't to the core empirical insight of the statistical discrimination literature, which is that when you take away from employers and other decision makers individualized information about characteristics that they care about, they may rely on race, gender, or other things that we don't want them to rely on as proxies for those characteristics. Or to flip that point, the more information about individual non-race characteristics that you give decision makers, the less likely they're usually going to be to rely on race itself to make decisions. And that point, I think, is true and important for policy purposes in many contexts. And I've, in fact, done empirical research demonstrating exactly that in the context of ban the box laws that take away employer access to criminal records. My objection is to the implicit and sometimes explicit suggestion that statistical discrimination is less troubling than taste-based discrimination. So let me start by saying how disturbing some of the language in the literature is on its face, like the suggestion that it wouldn't be prejudice or animus or a racial taste to choose not to hire people because they're Black, but then to explain it away by saying, but it's not that I don't like Black people, it's just that I think that they're lazy or unproductive or criminal. This is, shall we say, a thin line to draw, right? In addition, there's no legal distinction between taste-based and statistical discrimination. I've already mentioned that the law, especially constitutional law, takes a super narrow approach to what unconstitutional racial discrimination is. It requires purposeful unequal treatment on the basis of race. But even this approach isn't so narrow as to be confined to taste-based discrimination. Rather, there's extensive Supreme Court case law holding that discrimination on the basis of prohibited characteristics like race and gender is illegal, period. What matters is that you take the prohibited characteristic into account and not why. And that's true even if you've got empirical support for whatever your reasoning is. For example, the Supreme Court held that it was unconstitutional gender discrimination to set different drinking ages for men and women, even though statistical evidence showed that young men were 10 times as likely to drive drunk. The court said, yes, that may be true, but not all young men drive drunk, and it's not fair to treat them all more adversely than women on the basis of what a subset of men do. So the basic idea here is that individuals have a right to be treated as individuals and not subjected to generalizations on the basis of gender or race. Now, I know some of you are in your heads pushing back and saying, okay, Sonja, you are misinterpreting the statistical discrimination literature. Nobody thinks statistical discrimination is okay. It's just that it's different from other forms of discrimination, and it's important to distinguish it empirically and theoretically because it may help us to redress it more accurately. To which I say, maybe that's what you think, in which case, fine, my quarrel is not with you. But I do not think that every economist agrees with you. There is a strong vein of thinking in economics, including in law and economics literature, that does imply that the distinction between case-based and statistical discrimination is normatively important. And I know that because the way that many papers are framed otherwise doesn't make sense. So for example, take all of the many papers that seek to empirically estimate taste-based discrimination only to separate out taste-based discrimination from all other explanations for racial disparities in some kind of outcome. These include in criminal justice and actually in other fields, in other areas too, every paper that uses an outcome test or hit rate model to assess discrimination, of which there are tons in criminal justice. So many papers have sought to address, to estimate discrimination in bail or parole decisions by asking whether there are racial disparities in the rate of criminal offending while out on bail or parole. The implication is that even if there aren't, then magistrates or parole boards are predicting risk equally accurately across races, and that this in some meaningful way means they're not discriminating. Other hit rate studies compare the rates at which police stops produce arrests using the arrest as implicitly the measure of whether the stop was justified, and thus using the arrest rate disparity, if any, as the measure of whether police are making unjustified stops at racially disparate rates. There's lots of other examples. There's lots of empirical or normative concerns with these approaches, but what I'll point out here is that they invariably rely on a model that defines the discrimination being measured as taste-based discrimination. And indeed, the classic hit rate model in criminal justice affirmatively assumes that racially unbiased police or other criminal justice decision makers would rely on race. For example, that police would pay attention to variation across races in the hit rate of searches and shift the focus of their enforcement until at equilibrium, hit rates become the same across races. So this model to a lawyer is totally incongruous since it assumes that an unbiased police officer does engage in unconstitutional racial profiling. And I have to ask, like, what is the point of trying to isolate taste-based discrimination in this way? Why is it a normatively important move? It can't be explained as trying to better understand the mechanism of statistical discrimination, that empirical insight that I just talked about, because in these approaches, statistical discrimination isn't measured. It's lumped in with all the possible non-racial explanations for racial disparities. And the papers advocating these outcome tests tend not to foreground the narrowness of the definition of discrimination that they're using. They typically don't point out that it's not the way that the law defines it, or that it's not the only form of discrimination that's morally undesirable. And so readers, especially non-technical readers, are very likely not to understand these points, even if the authors believe them to be true, right? And unsurprisingly, police departments have seized on these outcome tests since they define discrimination in the narrowest possible way, one that does not always absolve them of it, but is most likely to absolve them of it. And not only that, they have claimed that hit rate tests in which their departments come out with equal hit rates across races prove that they're acting lawfully. They have actually introduced it in as a defense in anti-discrimination lawsuits. And they've claimed that this means that they're not engaging in unconstitutional discrimination, even though the underlying models actually assume that they are and measure something different, right? So this is a danger of using a model of discrimination that doesn't resonate with what most people outside the economics profession think of as discrimination. Other audiences are going to misunderstand it and assume that the results mean something different than they mean. So another example is the one that I already alluded to before, the large literature on risk assessment instruments, and particularly that literature that compares the predictive accuracy of those instruments across races. To use that as the relevant metric for evaluating those instruments is in essence to embrace the idea that discrimination is okay so long as it's based on something that is accurate at the group level. Just to circle back to that paper of mine and Amanda's on beyond the box laws. So we found that racial discrimination skyrocketed after beyond the box was implemented. And only at firms whose applications the law affected. We found that using an auditing method. And I think it was pretty clear evidence in favor of the idea that employers were assuming that Black applicants were likely to have criminal records. But then as we started presenting these results, we consistently got the question, are the employers right? And that's also a question that in some form I've gotten when presenting criminal process discrimination results on other papers too. Like, okay, so prosecutors are discriminating, but could they just be accurately guessing who's going to commit a crime? So in the Beyond the Box paper, to address those questions, we put together a model where we backed out employer priors about criminal records and showed that they were wildly exaggerated compared to the actual distribution across races of criminal records. And we concluded that employers were stereotyping and not engaging in empirically accurate discrimination. And I'm sure that including that finding made our results more compelling to many readers. So I suppose it was worth including. But I have to say that, when I hear questions like, are the employers right? My lawyer brain also turns on and I cringe a little. I want to emphasize, it doesn't matter whether the employers were right. It doesn't matter if prosecutors are right. If they're relying on racial generalizations about particular racial groups and criminality in order to make decisions, it's unfair to all of those individuals that they're inaccurately applying those generalizations to. It's illegal and it's racist. And honestly, although our findings in the Beyond the Box paper have policy implications for Beyond the Box laws, none of them actually turned on whether what was happening was pure stereotyping or rational statistical discrimination. We included the evidence of stereotyping to ensure that no reader could dismiss our results as being less normatively important. But if we hadn't found that evidence, if we had found that employers were relying on accurate assumptions about the distribution of criminal records by race, I don't actually think that it would have made our findings of discrimination any less important. So final example that I'll touch on briefly is analyzing, it connects to my work on analyzing racial disparities in criminal sentences. So for decades, researchers have been trying to estimate unexplained racial disparities in criminal justice outcomes, like sentences. So by unexplained, I mean unexplained by observable case characteristics. Typically, the unexplained gap is implicitly or explicitly attributed to racial discrimination based on a selection on observables assumption. So studies like this have overwhelmingly found unexplained racial gaps in sentences that are statistically significant, but generally not enormous in size, 10%, 5%, maybe 20% at the upper end between Black and white defendants with the same observable criminal conduct related variables. So those are not trivial gaps. But on the other hand, if you look at raw incarceration disparities, you see that Black people in America are something like 500% more likely to be incarcerated than white people are. And so one takeaway from studies like these could be that once you control for past and present criminal conduct, most of the incarceration gap disappears. Crime, not discrimination, appears to be, in this interpretation of the results, by far the most important driver of incarceration disparities. Is that interpretation right? I think only if you take quite a narrow view of what discrimination is. And if you don't take such a narrow view, then at best, you can say that we don't know, right? So for example, for many years, virtually every study of sentencing took exactly the same empirical approach. They would regress the sentence on race and on other variables, including the recommended or presumptive sentence under the applicable sentencing guidelines for the jurisdiction. So those guidelines base those presumptive sentences on criminal history and on the severity of the offense of conviction. Those are the two axes of a grid that tells you the recommended sentence. And one basic problem with this approach is that the guidelines recommended sentence is not at all an exogenous measure of criminal conduct in the given offense or even past offenses in the criminal history variables. Rather, it's the end point of a long series of discretionary choices by criminal justice actors. First the police, then the prosecutor, who like cops has almost unfathomable discretion and power to shape the initial charges, the terms of plea bargains, the final convictions. After the guilty plea comes sentencing fact finding, the determination of offense severity, which includes various aggravating and mitigating factors. Those depend on findings of fact by the judge and also factual stipulations by the parties. All of that gets you to a guidelines offense level. Then the other axis of the sentencing grid is criminal history, which might seem less discretionary, but the main issue with criminal history is that it bakes in all the similarly discretionary decisions that have been made by past criminal justice actors. The core empirical problem of all crime and criminal justice research is that neither past nor present criminal conduct is ever directly observed, right? You always just have criminal justice outcomes of some sort, like whether an individual was arrested or convicted, and those are being used as proxies for what they actually did. And in a study that purports to be analyzing racial discrimination in the justice system, it's quite obviously problematic to assume those proxies are accurate, right? So if the sentencing judge is capable of racial discrimination, then presumably so is the prosecutor, the cop, and every past prosecutor and cop and judge that the individual encountered. But sentencing studies have consistently filtered those out. So in some papers almost 10 years back now, my collaborator Marit Rahavi and I tried to improve on the standard method for estimating racial sentencing disparity. I think we did improve on it, but only to a degree. So we built a data set that traced cases all the way from arrest to sentence. So we could look at the cumulative disparity introduced throughout that process, that was unexplained by the earliest measures of criminal conduct we could get access to, namely the arrest offense and variables culled from the arresting officer's notes. And we used those instead of the recommended guideline sentence as our main control variable, plus criminal history, and we used all arrestees rather than the narrower pool of sentence defendants as our sample. And so doing so led to a larger unexplained disparity estimate, and most of it seemed to be driven by prosecutorial decisions. But I'm sure most of you immediately see the problem, which is that our approach still treated as exogenous everything that happened in that defendant's life right up through the arrest in the case at hand, all the policing decisions, all the decisions that produced the defendant's criminal history. So those things shaped our control variables and our sample. So we talked about this problem in the paper, at least, in which direction any biases we weren't observing likely cut based on other research. That's really all we could do. But it's still, we think we made an important contribution by showing the contributions of prosecutors to disparities, but it's still a huge limitation. And honestly, that's just the beginning of what we couldn't measure and what no study in this field really measures. Like another crucial thing that gets filtered out of nearly every disparity estimate is policy choices by those that write the criminal law, the sentencing guidelines, choose enforcement priorities. So one really well-known example of this is the distinction between crack cocaine and crack powder. Federal sentencing law originally treated the possession of a gram of crack as the equivalent of 100 grams of powder, even though crack is made from cocaine powder. They're like the same thing. Now it's 18-to-1 after a law reform, but it's unclear why there should be any difference at all. And because crack defendants are overwhelmingly Black, this has a starkly racially disparate impact. Another easy example is school zone laws, which jack up sentences for gun and drug crimes if you're near a school, even if your conduct has nothing to do with the school. And essentially they are sentencing penalties for living in a dense city where there's always a school nearby. You could give a lot of examples. When we design studies that measure only disparities in the application of law to identical criminal conduct, we ignore everything that's built into the law itself. And beyond that, the models used in most discrimination papers, not just in criminal justice, but also in employment and other fields, are completely not up to the task of assessing structural or systemic racism, like the many, many ways in which racism shapes the opportunities of individuals in ways that determine all of those factors that are often treated as non-racial explanations for disparities, i.e. as control variables, right? So criminal behavior itself, and also factors like education and poverty. Arguments like these have been raised powerfully by other scholars who go farther with them than I do, who suggest that we should never assess race as a causal variable, essentially because every control is a post-treatment control. I don't go so far. I think there are reasons that empiricists and lawyers and courts, for that matter, might want to know whether a particular decision maker's perception of race itself, as opposed to other variables shaped by race, is driving decisions. For one thing, that's what you generally need to prove in order to win a constitutional claim of racial discrimination in court. I also think it's worth documenting the fact that racism today in America isn't only structural or systemic in the sense of being like a pre-existing state of affairs. It's not just something we can blame on past generations, because racial discrimination, even in the narrow sense that courts recognize, still happens all the time, which you can see in like auditing experiments that hold constant everything else and find that it turns out that narrowly defined racial discrimination continues to occur. All right, so that's like a bunch of comments on a bunch of kind of interconnected things, which I'm happy to take questions about. But the overall message here is that it's really important to be explicit and careful about fleshing out like what the normative assumptions are behind empirical models, and to make that clear even to readers who may be looking at research from outside the discipline in which maybe some of those normative assumptions are taken for granted. Because when people read a study and kind of misunderstand what the discrimination is that's being estimated, they can really draw the wrong conclusions. Okay, that's it.
Wonderful, thank you very much. So our final speaker is Lawrence Bobo, who is Dean of Social Science and W.E.B. Du Bois Professor of Social Science at Harvard. He's one of the world's leading scholars, of course, on understanding racial attitudes, and has also written essential papers on understanding the thick concept of prejudice and its relation to the thinner concepts that one sees. As I said, in the case of Sonja Starr, she was somebody whose work I'd read for years, but had not met her before. As it happens, Loury, Bobo, and I met 45 years ago, almost on this date, when in my last high school debate, he was one of the judges. So there you have it. It's a small world after all, and I'm sorry to reveal he was the deciding vote in my defeat. But there it is. Anyways, it's great to see you. I don't think we're going to make it to the next 45, but please, the floor is yours.
We got to go back and unpack this history someday, because I did not realize that. But let me begin by thanking Steve and Jeff for inviting me to be a part of this session today. I really am envious of the opportunities that we have to bring together interdisciplinary groups to engage on common lines of inquiry and underlying social problems. And I've already found this an enormously generative gathering. Let me begin by saying that in two senses, I've taken seriously the invitation I was given, which was to aim at concepts and theory. So this is not a data-driven talk or a particularly empirical talk in a way that's characteristic of much of my work. It really is going to proceed largely at the level of theoretical discourse. And quite frankly, being a dean means I have very little time to literally just think, research, and write, especially in the year of COVID. So it's been hard to put my focus on new empirical work. By way of background, for those who might not be familiar with me or my work, I'm a sociological social psychologist. Most of the work I do is derived from sample survey data, whether it be at the samples of cities, the state, a state, or national data here in the US. And in that respect, I might forewarn that much of the literature I will talk about could be regarded as largely correlational in character, except for that work that really is over time or trend analyses. Although I've also helped pioneer in the use of experimental design within social surveys. I have kind of a three-part agenda here today. One part is to do some initial stage setting about, I think, traditional approaches to notions of prejudice and stigmatization. Then secondly, to really elaborate afresh and anew ways of thinking about what I regard as the most useful sociological approach to thinking about prejudice. And then very, very briefly at the end to kind of highlight some potential new and fruitful directions for research here. So let me go to the first piece of what I want to talk about here. And that's the view from, if I can get the slides to advance, we'll do that. There we go. The view of prejudice that I think has certainly dominated social psychology, psychology, and to a degree, political science research in this arena. And that's the view derived from the work of Gordon W. Allport, who initially defined ethnic prejudice as an antipathy based upon a faulty and inflexible generalization. It may be felt or expressed. It may be directed toward a group as a whole or toward an individual because he's a member of a group. Allport's definition, therefore, directs our attention kind of first and foremost to feeling states or affective orientations toward members of other groups, something that's got a substantial emotional bundle or element around it. It secondly directs us to stereotypes or beliefs. It leaves as a bit unclear whether those stereotypes or beliefs have a valence that adds up to the negative feeling, or if the negative feeling predisposes one to the selection and perception of views that are consistent with that underlying feeling. He didn't really resolve that. I will say kind of throughout what I'm talking about today, the extent to which I really engage work on stigma, it mostly derives from the extent to which some notion of stereotyping is embedded in the theory or the particular work that I'll be talking about. Now, of course, for Allport's view of it, part of what made stereotypes problematic, if I can get this, there we go, is that they were resistant to change, that this wasn't just a poor judgment. This was a judgment kind of with compunction, some kind of commitment to sticking with it, even in the face of potentially contradictory evidence. Although that emphasis in his work on ignorance as an underlying source of prejudice really did undergird his strong emphasis on bringing about greater group contact, especially contact under certain well-defined conditions, if one had the aspiration of breaking down the underlying antipathy. In much of what I'm going to say in a moment, I think of the Allportian approach, its sociocultural emphasis on the origins and fundamental roots of prejudice has done much to inspire the work in social psychology and political science, political psychology of David Sears, Donald Kinder, John McConaughey, many of their colleagues. Let me press ahead, however, to an even older model in some respects, and I'm doing this just for completeness, not because I'm going to invest enormous energy in it. And that is a real individual difference view of prejudice. That prejudice in the case of the authoritarian personality and Teodoro Adorno and others was really rooted in a deeply structured personality style or syndrome that predisposed one to inflexible styles of reasoning, strict adherence to a conformity-based outlook, and real hostility and readiness to aggress against those who were different or outsiders. And that personality structure was one really rooted in an overtly Freudian theoretical framework. the whole approach has been kind of modernized and made a little more contemporaneously relevant in the work of Bob Altmaier on right-wing authoritarianism, which views it more as a socially learned attitude that really does have some very well-definable sub-elements, such as the acceptance of conventional norms and standards and beliefs, especially with regard to prevailing views of outside groups or minorities. A real deference to conventional legitimate authority figures, and a readiness to aggress against those who are in any way outsiders, marginalized, or a stigmatized population. And then probably the most widely cited and used variant today would be Jim Sedanius and Felicia Preto's social dominance theory, where they argued that the core contribution of this kind of individualizing approach has always really been about group relations, with there being considerable variation across the spectrum of individuals who tend to be hierarchy attenuating in their orientation to those who are hierarchy enhancing or reinforcing in their fundamental psychological orientations, and that heavily maps onto where one is in the prevailing social structure as a member of a more dominant or privileged group, or a stigmatized or marginalized group. What I want to spend my time on, and kind of dedicated my career to, is trying to articulate a more sociological view of prejudice, and emphasizing that racial prejudice is kind of best understood as a general attitude or orientation involving a normative idea about where one's own group should stand in the social order vis-a-vis an outgroup. And that normative idea is that it's got a moral imperative to it, that the world ought to involve a particular type of relationship between members of my group and members of another group. Or as the real originator of this approach, Herbert Blumer, put it, for him, fundamentally, racial feelings point to and depend on a positional arrangement of racial groups, that is the core of the issue. The source of racial prejudice lies in a felt challenge to this group position, as I'll elaborate in a moment. For those of you who may not be familiar with the kind of group position approach, this was most visibly articulated in a little 7-page essay that Blumer published in 1958, and there's no direct data there, and he did not dedicate himself to any real empirical work on the matter, but it has come to exert kind of stage dominating influence within sociologists for our thinking about notions of prejudice. And Blumer in particular was, I don't know quite how to put it, he was openly antagonistic to Alport and psychologists, and indeed dismissed the classic book, The Nature of Prejudice, as a failed effort at eclecticism, to quote him, and positioned this whole theory literally as an elaborate response to a more individual focused psychologizing view of what prejudice entails and involves. So for him, he said there are really 4 elements that should be borne in mind in this theory. That, of course, the group position notion involves some sense of in-group superiority and attachment, which in other contexts I might just refer to as in-group ethnocentrism. That it involves also out-group derogation. You have to have an out-group that really is viewed as distinct, and in Blumer's language, as alien and different. He also suggests, though, that what makes prejudice an active social force, what makes it something that goads people to action, is a sense of entitlement, that there exists a proprietary or first claim on certain rights, statuses, and resources in a social system. And that is really animated and becomes most socially active when confronted with some perceived threat. When there is a belief that members of an out-group or marginalized group desire or are seeking a greater share of what have been in-group rights, statuses, and resources. Now, I should say, if you think about this long and carefully, which I have, I think Blumer's invocation of group attachment and outgroup derogation goes straight back to Alport, that's basically affect and stereotyping. And so despite his effort to create a totally different vocabulary and framework, he actually was building upon rather than negating what the Alportian framework directed us to be concerned with. Then from there are certain key processual dynamics that Alport put as center stage, Blumer, I should say, put as center stage. So in this account, interests and interest groups play a role in social dialogue that creates and sustains a sense of group position. This is necessarily collective. That is, it involves a very general abstract group-based notion of who's entitled to what. This really isn't entirely about a discrete, privatized individual making personal pocketbook logic choices. It's about people like me have a proper entitlement to a certain set of experiences, be it with respect to success in the economic arena, recognition and responsiveness by the state, regard and esteem from one's fellow citizens, that we're entitled to a certain baseline here that privileges us relative to other groups, that this is public, that there are big, broad issues of social discourse and events that help draw attention to and reinforce that collective sentiment, and that in this sort of system, it's leadership, public officials, activists who set the stage. They play a predominant influence in shaping the more salient features of the sense of group position. And now kind of lastly, I will say that from my vantage point, and I've done a theoretical essay that really tried to integrate really 5 papers that Blumer wrote, not just the one little 7-page piece that most scholars rely on, that have to be integrated if you really want to fully understand the position here. And at least as I think Blumer developed it, he would have suggested that ethno-racial cleavages are fundamental in social organization, that racial identities are quasi-autonomous social forces ranking with economic and other institutional dynamics in shaping human conduct and social organization. So this in a different and more abstract way reinforces the point that Sonja was just making about the dangers of putting race into an equation as an explanatory variable and then trying to wash it away by saying, oh, look, a piece of this is education. Oh, look, a piece of this is family structure. Oh, look, a piece of this is whether or not you have a criminal record, when race played a heavy role in structuring each of those so-called independent variables. All right, they were in effect endogenous to a system of racial oppression, which had some primary ontological status in generating those distinctions. Also for Blumer, emotions matter. That affect is central to the sense of group position. Remember, I said it's a normative construct. It's a should, it's an ought imperative here. So that we're not saying that the group prejudice involved here is fundamentally rational. It still does have core socio-emotional and in effect unreasoned aspects to them, but also interests matter. The configuration of interest and interest groups are central to this approach, since once a set of racialized inequalities have been long institutionalized, there really are meaningful interests that attach to group positions in a hierarchical and racially stratified social order. Now, having said all that by way of conceptual background, let me quickly say there have been tons of applications and tests, some of which I take a little bit of credit for myself. My early work on the politics of school busing and who opposes it and why, on attitudes toward affirmative action, on other explicitly race-targeted social policies, all tend to favor a view of this sense of group threat as driving much of the level of what we've observed in terms of opposition among white Americans to these policies. Similarly, if we're looking at studies of trend change in racial attitudes, or really try to theorize what I call a big reformulation of the dominant ideological structure to racial outlooks, we've essentially moved from the Jim Crow racism era of open de jure discrimination based on an assumption of clear-cut biological difference between Blacks and whites that justified open discrimination and really the prohibition of racial mixing, to an era of laissez-faire racism, where in theory we have a race-neutral, colorblind state, and where we don't embed racial bias in the law. But on the other hand, we allow people to make as many choices and actions that may disprivilege African Americans or other minority groups as a free market, putatively colorblind state may allow. That in part, then any inequality that exists is to a degree minimized and explained largely in terms of the cultural shortcomings and failings of the disadvantaged group involved, and that kind of matrix of ideas strongly predisposes a good chunk of the majority group to reject any claim for state obligation to undo or mitigate racial inequality. I've seen this applied, and one of my course students, Camille Charles, has her book, Won't You Be My Neighbor, applies this to the dynamics of racial residential segregation. My own work, Prejudice and Politics, Group Position, Public Opinion in the Wisconsin Treaty Rights Dispute, applies it to Native American white relations and shows very powerfully how that might work. There are a growing number of articles applying this kind of group position and threat argument to the politics of social welfare, of crime and punishment, and why we have become such a punitive social order, and why public opinion so routinely supports a highly punitive social order, and other implicit racial policy domains. There's an exploding literature in the politics of immigration that draws now on group position theory, critical books on electoral politics, such as Chris Parker and Matt Barretto's book on the Tea Party, and other folks' work on the election of Donald Trump, of course, and a smattering of work wrestling more directly with internal workplace dynamics. Let me try to wrap this up, if I can, quickly, with just a reflection on kind of some old debates and new directions, and then just open all this up. A lot of the work on the group position kind of theory was sparked in response to the modern racism, symbolic racism, racial resentment literature, which began as an effort to really reject individual pocketbook, as some might have put it, economistic reasoning about resistance to racial change, and argued that it wasn't narrow self-interest that dictated who resisted or opposed desegregation, who resisted or opposed affirmative action plans. It was a general underlying negative hostility to minority groups, that it was something psychological, it was something rooted in prejudice that mattered most. And it tried to actively negate the idea that interests played any roles, or that realistic group struggle of some kind might have been at issue, which is where I got initially engaged in this debate. A lot of the debate revolved around the meaning of responses to various questions in attitude and belief surveys. And I've tried to show repeatedly that much of what gets called racial resentment measures actually are declarations about rightful normative group positions and threats or challenges to those rightful or normative group positions, not an abstract, vague racial prejudice. There was another line of debate of folks arguing that the issue really isn't race at all. It's an issue of the legitimate role of government, conservative dispositions that are largely race neutral in their character. And I won't review it all here, except to say the bottom line is there is some important role for generally conservative views, but whether the issue was explicitly racial or implicitly racial, like welfare and crime, that perceptions around group position and threat were still the larger, heavier influence. There are classic debates over structure versus culture, and I'll shortchange that for here. If we want to go back to it, we can do it. The literature has finally started to move beyond the black-white binary and to do more to incorporate the views of minority groups, especially minority groups in a variety of multi-ethnic contexts. And there's a growing body of work that applies the theory in places like South Africa, in Brazil, in Canada, in various European countries as they deal with their formal colonial populations or immigration challenges of their own. So that is what I think of as the sociological approach to prejudice, stigma, and discrimination. It's the group position model. There are lots of questions to be answered in terms of measurement, in terms of articulation with other developments in studies of prejudice, such as implicit attitude work and the like. But that is my story. I'll stop there.
Fantastic. Thanks so much. So why don't we open it up to questions, comments, discussion?
Well, all right, I'll start then. So thank you everyone for a bunch of very interesting presentations. Dr. Bobo, my first question is for you. Group position theory has been influential for me as well, but it always sort of bothered me that there's no model of group formation in the theory, and that it sort of takes groups as like given, right? And then they interact and perceive one another and feel different ways about one another. But nothing about where they come from, how they're constructed, how their boundaries are policed. And it seems like group formation and group construction are tied up with a lot of the processes that are sort of theorized in the model, like affect, and that groups are constructed to protect or rationalize advantages of different kinds for certain individuals. So I just wondered if you could maybe reflect a bit about, where group formation fits into the model.
It's a great question. And as I was going through that era of reading all of Blumer's writings that could be construed as related to prejudice, I ended up right where you started with this question. Blumer didn't engage it. He did not attempt to give us a direct answer to the question of where groups come from, why boundaries may change. And but I think we could infer some partial answers that it certainly is an historical and emergent process, that it will have a good deal to do with the resources that, say, different individuals and groups are able to mobilize in a particular context. And now I'm totally speculating, but take the case of how the understanding of, say, white European colonists' interaction with the native peoples that they encounter here in what becomes the US begins, which typically opens as a trading relationship, right? With many of these groups and tribes, as they were viewed as very good and effective trading partners, that they could get us natural goods, pelts, and so on for other products we could provide. That positive view of the relation and of the individuals of the group changes enormously when the emphasis becomes one on permanent settlement and claiming chunks of the space. And then you get leadership segments staking claims, right? And that butts heads eventually with those who thought it belonged to them previously. And then the real issue historically becomes, kind of sadly to put it this way, who wins? Kind of what gets institutionalized. And then at that point, the full dynamics of the group position model kind of come into play. But I think the other thing I would add quickly is that in circumstances of open conflict, some of the mechanisms to resolving the conflict toward reducing overt tension and hostility can be tied to broadening a conception of the boundaries, right? Who's in group or who exhibits qualities that would qualify one for group membership and comparable treatment. So the danger of open conflict situations, especially if avenues toward reconciliation aren't found, right, is that they push toward accentuating that difference in ever greater in the extreme, ever greater hostility toward the outgroup. But I guess that's my partial answer. So it's emergent. It involves those elite actors, and it's very much historically contingent on a variety of factors in the situation. But you have to concede that the origins of the theory and almost all the work myself and others have done subsequently doesn't directly engage this question of boundary formation or boundary change.
I can go next. Steve and Jeff, thanks for organizing this panel. And Larry, and Sonja, thank you for some terrific comments. I know that this, looking at the sociological perspective certainly gives me a lot to think about as an economist by training. I want to direct two questions. So one to Larry Blume, which has to do with, can you talk a bit about how generational considerations factor into evolutionary game theory? So for example, how do you think about the actors looking towards the future and the ways in which their actions today are going to be impactful tomorrow? So if you can talk about that, are they myopic, or do they have a long view of the future? And how does that change the kinds of equilibria that you see? And then to Sonja's point, I think you bring up something really important, which is what's the purpose of social science at the intersection of law and economics if the social science itself is ahead of where the law needs to be? So I wonder if you can talk a bit about that creative dialectic tension in terms of, are there instances where social science needs to go beyond where the law is so that we can inform the way in which the law could potentially operate, versus taking the law as a constraint and then writing down algorithmic models that are quote unquote legal within the context of where the law is today?
So who amongst us should go first?
You go ahead, Larry.
All right. So Peter, I think you're actually raising a very important point, because much of received evolutionary game theory is very myopic. I can think of only 3 papers, actually 4 papers, I guess, that actually do evolutionary game theory with forward-looking players. Actually, I'm the author of one of those papers, and that's the title. And I think that it's technically challenging, but not as forbidding as it was once thought to be. And what you learn from this are kind of surprising. So I'll give you one brief example, and then I'll stop. Just think about a population of people being matched to play a coordination game, where there is a strategy which is so we'll imagine that there are 2 strategies that one could play, strategy A or strategy B, and the payoff, if we all coordinate on A, is higher than the payoff if we all coordinate on B. Okay, and then second, of course, it's worse to miscoordinate, okay, than coordinating in either A or B. But if we miscoordinate, the A player really pays a big cost for the miscoordination. Okay, so this leads to a situation which in game theory is described by saying that the A coordination outcome, the A equilibrium, is Pareto dominant, and the B equilibrium is risk dominant. And what the typical evolutionary game theory models show is that the focal equilibrium is the risk dominant equilibrium rather than the than the Pareto dominant, the payoff dominant equilibrium. And the reason for this is basically that if we think about the dynamics, the basin of attraction for the risk dominant equilibrium is bigger. Okay, now, so that is maybe not so surprising, but what surprises me is that when you make people, so I would have thought that if people were really, really patient, okay, they wouldn't worry so much about these kind of short run fluctuations and falling into the risk dominant regime. And this should lead to, at some point, the emergence of Pareto dominant equilibrium as being the focal equilibrium. And so I investigated this, and this turns out to be false. And in fact, quite the opposite is true. What happens is that as you make people more and more and more patient, the basin of attraction of the risk dominant equilibrium expands. To be basically everything by the time people are perfectly patient. So I think that there's number one, I think that there are tools that are not very hard, that we all know from, like, macroeconomists know, that allow us to address this kind of thing. And two, the results are really surprising. And pretty interesting. And I have a paper on stigma, which I can send you, where I actually do some of this kind of stuff.
So, okay, I'll jump in now. Thanks for the question, Peter. So I think, certainly there's no reason that social scientists' approach to discrimination, even when it's meant to speak to legal questions, needs to necessarily be confined to definitions of discrimination that are prevalent in legal doctrine. One reason for that is that there's lots of, there's not one approach that lawyers or law scholars or courts take to discrimination. There's different approaches used by different people and entities, but also for different purposes, right? So the questions that I raised, for example, about how economic theory and social science research on discrimination generally has been poor at speaking to questions of structural racism or systemic racism, and also has, adopted overly narrow definitions of discrimination that filter out many things that are essentially race proxies or are invariably deeply bound up with race. The broader views of discrimination that might conceptualize, that might incorporate those kinds of concepts would also be broader than the traditional view of discrimination that I explained is how US courts think about unconstitutional discrimination. But helping courts decide what discrimination is unconstitutional is not the only function of scholarship in law and social sciences or law and economics, right? So it's also the case, for example, that legislatures and sentencing commissions and policy advocates in general make a lot of policy choices for reasons that are not just what is constitutional and what isn't, right? So the question, like, what is the racially disparate impact of the way that of school zone laws, for example, or the crack powder distinction, or the way that our sentencing law gives heavy weight to criminal history, for example, or the way we treat violent crimes versus nonviolent crimes. Like, all of those questions don't resonate for courts in terms of constitutional claims, because there, the only thing that really matters to the court is whether discrimination, or whether race is being purposefully taken into account. But they still should matter, I think, from a policy perspective, as to whether all those rules should be adopted or should be kept on the books, right? There's quite a bit of room for social science to speak to lawyers and creators of law and advocates about law and policy issues in deciding those things. A specific example that I gave about when it's worrisome that I think people in other fields are kind of unaware of the legal constraints, was the example of like the algorithmic risk assessments that some computer scientists are trying to develop that are race conscious in a way that is designed to alleviate racial inequalities in the end. And the reason I think that it's that those algorithm designers need to be particularly aware is of the legal constraints is actually that like they are designing algorithms that they're hoping could actually be used in the criminal justice system. And when you're designing, tools to be used by government decision makers, then you're not just trying to inform constitutional analysis, you're also creating a tool that could be struck down by courts as being unconstitutional, right? Because the choices that government actors make are constrained by existing constitutional doctrines. And so I think it's super important for algorithm designers to realize that they can create such a tool as like an intellectual exercise, and of course they can create it for use in other countries that aren't bound by the same constitutional doctrines, but that they're going to if they really want to provide tools that are going to be used in U.S. courts, they need to be aware of the way that courts are likely to react to them. The final point I'll just make is that, of course, many of the things that I pointed out in my talk were that the field of law and economics and of economic research on criminal justice has often not been ahead of the law in terms of defining what inequality is and taking a sort of progressive view of how to address broader forms of inequality, like structural racism. In fact, law professors love to criticize the law itself and judicial doctrines for being overly narrow in their definition of what discrimination is. But somehow large veins of economic scholarship manage to be even more narrow than that. And so I think, yeah, right. So that's one of the points I wanted to highlight.
Thank you.
My name is David McMillan. I have a question for Professor Starr. So given the issues that you brought up a few times about, estimating racism by controlling for a number of factors that could themselves be mechanisms through which racism operates, what are some basic recommendations you would make for how to define and measure and estimate systemic racism? Figuring out, what exactly is systemic, what is not systemic racism? Is this something that needs to be measured, from birth in some sense? If there's this sequence of things that people experience from birth that could have put them down like a certain path by the time they get involved in the criminal justice system and so on. So what recommendations would you make for like defining and measuring and estimating systemic racism in a way that would be useful in economics, but also in law?
That's a great question, and I don't necessarily have like a comprehensive answer to it. I would say, by the way, there are sort of sub threads of economics that have done work that is useful in understanding systemic racism, like work on how wealth gaps, say, transmit themselves across generations, right? Like that's part of the dynamic of what perpetuates race gaps in wealth over time, and is part of what constitutes systemic racism in society. I just think that often those veins of scholarship that are focused on these broader historic trends or broader societal trends are often not, they often don't really speak to like the research that's about estimating discrimination in micro level decisions by decision makers like police officers, for example. it's like there's ships passing the night with those kinds of, with those bodies of scholarship, and the micro discrimination scholarship kind of proceeds under implicit assumptions that that all those broader factors don't really exist. So what can you do? Well, one thing is to take more seriously something that I think that economists, and not just economists, but people in like many areas of public and academic life are too dismissive of, which is like raw disparity statistics, right? So so for instance, disparities overall in incarceration rates in America, right? A lot of people will point to the 5-to-1 or 6-to-1 ratios or something like that in disparity statistics and say, oh yes, but that doesn't really tell you about anything about racism or discrimination in the criminal justice system, because it fails to account for differences in criminal conduct or other differences that aren't like non-racial explanations for those differences. And I think it's important to dial that back and say, like, actually it does tell you something super important, right? It identifies a really major social problem, and one that is bound up in the history and present dynamics of racial discrimination in ways that are probably deeper than any empirical model is likely to be able to tease out, but like the raw numbers tell you something that's important, right? And similarly, if you can look at, like, to analyze the racially disparate impacts of policies requires really the tools of causal analysis of policies and impacts on and evaluating the impact on like more raw racial disparities that don't control for a bunch of for other race correlated characteristics, right? So to say, like, what is the effect, for example, like we in our Beyond the Box study focused on the effect of Beyond the Box on discrimination as between people who have otherwise identical characteristics, which we forced to be identical via field experimental design, right? But another important question is just like, what are the effects of a policy like Beyond the Box or any other policy that might be of interest on actual disparities between Black and white levels of employment when you don't throw in a bunch of the control variables that filter out the race correlated characteristics that might actually be shaped by race. So anyway, those are just some ideas, but I feel like it's there's a lot of room for smart economists to come up with new strategies for getting at this. I think it hasn't been the core focus of the discipline, even the part of the discipline that focuses on discrimination. And I hope that as US society, it kind of grapples with these broader questions of systemic racism in a more sophisticated way that it has in the past, that will also become true of the legal discipline, the economics discipline, and other social sciences as well.
Thanks so much. I hope we can talk again about this.
Great, yeah.
I'm going to arrogate the right something to that, and I hope it doesn't embarrass you. David McMillan is just finishing his PhD in public policy and joining the economics department at Emory. His dissertation is on exactly this question. In other words, how we should address the concerns about systemic discrimination constructively by expanding models. And so the type of work that he does is going to describe individual decisions, but then it's going to look at the emergent consequences. In other words, you look for properties that occur at a different scale than the individual choices. And so that is one of the ways that one could constructively characterize what it means to say the system is producing disparate and unjust outcomes as opposed to individuals in isolation. So and so it uses techniques from systems theory and complexity. I think the second, which was implicit in part of what you said, is that in thinking about models and kind of what it means to say there's discrimination in them. There's a question as to whether the models have internal correction mechanisms or they're corrected or disparities fluctuate because of shocks. In other words, metaphorically, if I take an economy and I suddenly switched off all the discrimination and all the stochasticity, what happens over time? How fast do the disparities disappear? And so that just speaks to trying to use theory to structure not the analysis of nonlinearities. The third example is what you referred to before, which is to say that the system has rules that one can map directly to disparities, and that would be the cocaine types of cocaine and justice differences. But the main thing is I always want to, since he was too modest to do it, when I emphasize that he is, as we speak, working on exactly that question and has made a lot of progress.
That's awesome.
I have a question actually for the whole panel, perhaps for more specifically for Sonja and Professor Blume, because they explicitly spoke about that. I was wondering if you all could comment about the potential fragility of policies in a dynamic, complex system like the one we're studying. And I know this is a pretty broad question, so let me put a little bit more structure on it. So I think just for now, just think about the idea that we want to, just for the sake of argument, we want to try to minimize inequality of opportunities. Let's say that that's our goal. But we actually do not quite know what should be the protected categories, right? Most of us have been speaking here about race, and that's clearly a very salient protection dimension we should worry about. But in the past, we have seen that many times there are categories that come to light only after many policies that happen end up harming them. Like, for instance, we can think about, for instance, for a long while, a lot of people at least were aware of the struggles, say, for the gay community. But at that time, we were still not aware of a lot of the struggles from transgenders, for instance. And only later we found out there were specific struggles about a minority that ex ante we did not know about. And then, so how to think about things that would not only be correct with our current understanding, but would also be, we would take into account more awareness about the complexity of the system and about the fact that there are unknown categories of minorities that we yet do not know, and exposed, we don't want to be in the wrong side of history.
So I will say that I don't know how to do that in an empirical model other than to be kind of alert to woke, if you will, to like kind of sources of inequality and oppression that might not have traditionally been the focus of empirical analysis. I'll say that in the law, I think it's important to have a sort of flexible living constitution type of approach to what unconstitutional discrimination is, because otherwise, we get stuck with these sort of reified old categories that don't evolve with cultural norms in the way that I think that our law should evolve. So that's a very brief answer to a big question.
So let me add to that and say that the problem of group emergence is really difficult, and I don't think that any social science yet has really any good theories of how groups coalesce and come together and join into the processes that Professor Bobo was talking about, for instance. So my view is that absent the model of that, it's hard to do empirical work that has to do with the causal effects of policy. And so I don't know really where to go with that. I guess, well, I'll just stop there. I think it's a really challenging problem, and I think the one thing that, looking at the kind of models that I've dealt with has taught me is that a lot of what we think we know is this is what I concluded with in my presentation, is really incredibly fragile to small details of how interactions actually take place. And I think that we've not been very sharp in our modeling of how people actually, interact with each other. So in order to get at least some of the issues that you're talking about, I think that we're going to have to do, that we economists are going to have to do a much better job of integrating some of the insights of social psychology into how interactions actually take off. I think of this a lot in the context of Susan Lohmann's work on the Leipzig riots that led in 1989 to the collapse of the wall. And so she does this dynamic analysis of how the idea that you can get away with demonstrating is a contagious phenomenon, right? And how that contagion might take place. And it's a really cool piece of work in many ways, but it entirely leaves off the question of, who are the first guys who went out there, right? What was the germ, and the initial stages. If you kind of build different models to look at that, you see that whether these processes begin or die depends upon basically what happens at the very beginning, which are very micro level interactions. So that's all I have to say.
So in the interest of being a Chicago zealot, let me also mention that I think your question relates to this extremely interesting work by Aislinn Boren, who's here with Alex Imass and Devin Pope, and I guess it's Kevin Agag, on inaccurate statistical discrimination, where the idea there is to ask what happens when people have misspecified models. They may be accumulating data, they may be, observing what other people think with their misspecified models. And part of what you were asking is how do models update? In other words, people have worldviews, so to speak, and they may accumulate data, but the question is, do they do it to the confine of how they think, you get more accurate parameters or what have you, or do you actually start to engage in a process of changing the models that one works with? And that strikes me as extraordinarily important. That's part of what you asked, is the demography of the United States and the population changes either in terms of the distribution of members or the distribution of members who are in a position to have a voice. And then you want to ask how you would adjust those things. So it strikes me that I think that's a splendid paper. It really is worth using that as a prism for these questions.
Thank you.
I interpreted, maybe I was wrong, Gregorio, but I thought maybe your question was about what's the process by which we as a society come to recognize something as discrimination or important as worthy of remedy. And one example of that I thought came up in your talk, Sonja, was where you mentioned how when you presented about employers discriminating after ban the box because they were inferring one group was disproportionately had criminal records, and then you get asked, well, are they right? The presumption there is that it's fine to discriminate against people with criminal records, right? And so I wonder, maybe you could comment a bit about on how certain types of discrimination are just viewed as normative and fine and no one bats an eye about, for instance, against people with criminal records, versus are, strongly non-normative and the subject to massive legislation and debate, and sort of when new categories start to sort of move from one to when new groups or types of discrimination start to move from one category to the other.
Yeah, I would add that it's not just that the assumption is that it's okay to discriminate based on criminal records. The implicit assumption is that it's okay, or at least a little bit better, to use race to discriminate indirectly on criminal records by using race as a proxy for them, i.e., to rely on racial generalizations about criminal records. And so that's the move that I think courts would object to, that in which the statistical model, statistical discrimination distinction doesn't track the way that lawyers think about racial discrimination. However, I'm going to get to your broader point, which is, why do we think it's okay to discriminate based on criminal records in the first place? I will say that particular issue is not taken for granted by everybody in the legal world or in the criminal justice world, and there is a growing movement to try to to reduce discrimination and stigma attached to the possession of criminal records, and to open doors for people with records. And that, of course, that is the really admirable objective of Ban the Box itself, right? Like that, it's designed not to completely prohibit employers from taking criminal records into account, because it doesn't prevent them from ultimately doing background checks at the end of the process, but at least to make sure that employers aren't imposing blanket restrictions on people with records from the beginning that don't take into account their individual strengths, right, and the job relevance of the criminal record. Our research points out that there's like an unintended racial consequence of that, but it doesn't mean that the underlying objective isn't important, or one that is kind of widely recognized as important in the field, right? Just grounded not just in the racially disparate impacts of discrimination against people with criminal records, but also just in the fact that people with criminal records, regardless of their race, are like human beings who merit being evaluated on something other than like the worst actions of their past. And the movement toward expungement of criminal records, including like the growing clean slate movement toward automated expungement of criminal records, which is also something that I've done a bunch of research and advocacy related to, is also motivated by that same thing. So I think that's an example of the general phenomenon that you're describing, of how over time, like, society begins to recognize maybe dimensions of inequality that we have previously taken for granted, that actually may constitute an injustice. And I don't actually think our society moves inexorably toward the reduction of all such metrics or all such like vectors of inequality in society. I think that I hope that the arc of the moral universe bends towards justice, but I think it doesn't always. But I think the call for us in empirical research and in social sciences, whether theoretical or empirical, and in the law, is to interrogate our own assumptions as to like what are the justified bases and for treating people differently, for it can't be the case that all differences between all human beings are inappropriate for decision makers to take into account. But I think it's the case that like there are people, that the views of individuals and of society on what are appropriate things to take into account evolve all the time. And I think it's really important for us all to realize that like we probably hold views now that our children and grandchildren will condemn us for, and that we need to be open to the possibility of society, of not just society having been wrong, but of us individually having been wrong, and to reconsider that in our work and in our personal lives.
So given the time, I think we probably need to come to a close. That said, I would like Larry Bobo to respond to Jeff's question if he would like. One of the very important things you referred to was the normative dimension of prejudice. In other words, it's not just a matter of material interest, it's a matter of people having some ethical views that justify these things. And so Jeff's question in that domain is asking what's known about the capacity for evolution in that class of phenomena. And the reason I kind of harp on that is that in conventional economic models, to be precise, there's some idea about preferences, an idea about constraints, an idea about beliefs. Larry gave the Holy Trinity in his first presentation, but it does miss the normative dimension to how people think. And many economists think you can reduce it down to a statement preferences, and that seems to me wrong, but that's another conversation. I just think here it would be valuable to have your perspectives on normative evolution.
Yeah, I certainly thank you, and it's an important question. And normative change can happen, but and I'll give a concrete example in a moment. But I think it is complexly determined, to say the least. If we were to think about the extant literature on changing racial attitudes in the U.S., where I kind of began my graduate career in empirical work, our kind of core finding and conclusion is that the US did undergo an enormous normative transformation with regard to race, that the prevailing ethos of not merely the acceptability of white privilege and of open, literally de jure discrimination against African Americans, at least in the South and in many ways beyond the South, were acceptable. It was polite discourse. It was taken for granted. It was not intrinsically problematic on its face. The transformation of that normative environment is contingent on a number of forces, in part collective mobilization demanding a different moral order, in part a wider kind of, I think, context, both politically, economically, that were increasingly favorable to that normative transformation taking place. And however, there was nothing inevitable about it. I think it did require human agency. It required conscious action. It required social organizing. It required the development of power resources to change the dynamics of a situation. But we moved from a Jim Crow social order to one, as I say now, I would characterize as a society still beset by systemic racism, but it's not Jim Crow racism. It's this thing I call laissez-faire, or as some might put it, neoliberal racism that is the organizing principle today. So if there are forces to look to, in a way, it goes back to some of what I was arguing for in the group position model, that it is historically emergent and contingent, that activist elements articulating views of what the desirable system ought to be and the principles that should guide the operation of that system. And then much will turn on a broader configuration of power resources, I think, on the part of critical social actors in a particular historical moment or conjunction, as it were. But certainly normative change is possible. To maybe connect this to the last point about kind of what groups or boundaries sort of are at issue. I mean, I almost go back to the question that Jeff started me with, where I think the theories certainly I'm most well versed in the empirical research are ones that take the existing array of groups as kind of given and don't give us deep or powerful purchase on what makes for the potential for transformation, except to say, I think the implication is things that broaden a conception of group membership, things that reduce the perception of difference along important traits, contribute to more harmonious, more integrative sense of creating just, equitable kind of outcomes across prior boundaries. So I'll kind of conclude with that thought.
Wonderful. Well, I'm 100% certain I'm speaking for everybody to thank the panelists for a fantastic discussion. Very grateful.